Hi, everyone. This is Sam Silverman, Managing Partner of EB-5 Affiliate Network. Thank you for taking time to join us for today's webinar. Today, we're going to be discussing EB-5 source of funds best practices with a focus on South Korean nationals. During today's webinar, if you have any questions, please use the chat box on your screen and submit them. And then at the end of the webinar, we will try and cover as many of those questions as possible. Also, if you have to leave early or if you need to review something again or reference this webinar, we will be posting this on our YouTube channel, a full recording of the entire webinar. And if you're interested in getting the slides, please email us at the email listed there, info@eb5an, and we're happy to share the slide deck as well. So quick overview of what we're going to cover today. First, a little bit about the panelists on today's webinar and EB-5 Affiliate Network. We'll talk about what is source of funds, how does it fit in with an EB-5 investor's petition, some common issues that EB-5 investors need to be aware of, specifically best practices for South Korean nationals. We'll talk a little bit about a specific case study, and then we'll open it up for questions at the end. And again, for any questions, use the chat box and we'll address those in the order they come in at the end. So before we jump into the slides, for those considering a project for EB-5, it's important to determine if a project qualifies as a targeted employment area, which means that the minimum investment is $900,000 instead of $1.8 million. We have a new tool that we just launched on our website, TEA Map. You can type in the address of any project in the United States or Puerto Rico and immediately determine if a project qualifies for TEA status, and also generate a letter confirming that completely for free. So we've had almost 5,000 people have used the tool since it's launched just a few weeks ago. So very effective and free way to see if a project will work as a TEA area. Also, for additional source of funds information and general information about the EB-5 program in general, for developers and investors, we just recently published our new EB-5 guidebook. This is our 6th edition, so it's as up to date as can be with the latest rules, regulations about the program and about how to structure projects for investors. So it's available on Amazon, or if you want a digital copy, we have free PDF download as well, eb5guidebook.com. So as I mentioned earlier, I'm Sam Silverman, Managing Partner, EB-5 Affiliate Network, joined by my partner, Mike Schoenfeld, who's in the middle here, and I'll let Mike jump in and quickly introduce himself as well.
Perfect, thanks Sam, and really appreciate everybody taking the time to join this webinar today. So as a bit of background, I'm Mike Schoenfeld, one of the managing partners of EB-5AN, and both Sam and I used to previously work at the Boston Consulting Group before we started this company. Part of our focus in EB-5 has been bringing institutional knowledge and transparency into the EB-5 process, and we've grown our business over the past 7 years to become one of the market leaders in EB-5.
So as a bit of context, a little bit about EB-5AN today. We're a national regional center operator and fund manager. Across all of our sponsored EB-5 projects, we have more than 1,800 investors from over 60 different countries. We got started in 2013. We have many regional centers covering more than half of the United States and 100% approval on projects associated with our licenses. And we'll be talking about a couple of those projects later today. So this is a map of our regional center coverage area to give you an idea of where we can sponsor projects around the country. And this is a global map showing where some of our investors come from around the world. So today have the pleasure of having Evelyn Hahn join us as a panelist on today's webinar, talking about best practices for source of funds for South Korean nationals. Evelyn is a managing partner, or the managing partner, at David Herson and Partners, one of the top EB-5 immigration law firms in the space. And we worked with Herson and Partners on several different projects and matters over the last 7 years. And Evelyn has been deeply involved in the EB-5 space. And so I'll let her jump in and introduce herself and share a little bit about how she got into EB-5 and what some of the issues and things that she's encountered working with Korean investors have been over the years.
All right, Sam, thank you. Hi, everyone. My name is Evelyn Hahn, and I am the managing partner at David Herson and Partners. We're located in Costa Mesa, California, and we have our second office in Seattle, Washington. It is a great honor and a pleasure for me to speak to this audience who are interested in learning more about the source of fund strategies pertaining to South Korean EB-5 investors. And I'm really grateful to the EB-5 affiliate network team for inviting me and giving me this great opportunity to participate in this awesome webinar. So why and how did I get into the EB-5 world? So first of all, I became an immigration attorney myself because I was an immigrant myself. So I came here at the age of 14 when my father, who was an executive of the top conglomerate company in South Korea in L1 visa, and then we adjusted our status to EB-1C green card to my father's company. And after my father decided to quit his job and stay in the US for our better education instead of going back to Korea, we began to experience a very, very challenging immigrant life where we all had to work multiple different jobs to literally survive. So my parents, who didn't speak the language at the time, were defrauded by different business partners and lost their life savings. And I was also falsely accused of causing the car accident, which was not true. And I got involved in multiple different lawsuits. So basically, I spent my entire 20s representing myself and my family in nasty litigations. And that's when I realized that I need to know the law to protect myself and my family. And I also wanted to help others who find themselves in a similar situation I was in, because it was very, very painful experience. So that's how I got into law in general. However, my dream has always been to do something related to business. So after I became an immigration attorney, I was constantly looking for the options where I can get myself somewhat involved in, business-related work while practicing law. And when I found out about EB-5, I literally had this aha moment because I realized that it is a perfect option for me to practice law and at the same time indirectly participate in business side of practice by working with multiple different parties involved, such as regional center, developers, business plan writers, economists, and securities counsels. That's how I ended up practicing EB-5 immigration law. And I literally feel like every day I'm living my dream because it's just so fascinating and interesting to practice as an EB-5 attorney. But before I joined David Herson and Partners, I used to focus my practice on other non-EB-5 related business immigration at a big firm, which I still actively practice today, such as E2, H1B, L1, L1B, TN, EB1, 2, 3. And I speak fluent Korean, and while I manage our entire law firm, I also lead our Korean practice. So ever since I joined David Herson and Partners, I actively look for opportunities to work with Korean investors because I myself was a Korean American and an immigrant myself, and I speak fluent Korean. So that's when I reached out to migration agents in Korea. I, travel to Korea almost 1 or twice a year. They have migration conference twice a year in Korea, and I always attended, and I try to get myself connected with immigration industry in South Korea. And that's when I started working with Korean investors. And also I still do have a lot of friends and relatives all live in Korea. So that's how I also get individual investors, not through the migration agents. So that's how I got myself into practicing specifically with Korean investors who are interested in EB-5. So our firm offers national and international clients nearly 40 years of experience in immigration law. So we provide a full range of legal services And we cover all types of immigration, not just EB-5, but all types of other business immigration law too, as well as family immigration. And we also handle corporate immigration compliance, criminal record evaluation for those who have, criminal records and want to see if there's any opportunity to apply for the waivers. We can do the evaluation and let you know. And also we handle immigration litigation, especially now. It is really critical to be able to file an action in federal court when cases are denied for absolutely unreasonable reasons, because that are happening. So we take those cases to court and fight the issues until the end. So our firm's founding partner and managing partner, my co-managing partner, David Herson, actually it's very interesting because he was present in the Senate in Washington, D.C. back in 1990. When the EB-5 bill was marked up and Senator Biden, now president-elect, was debating the proposed new EB-5 law, so he was there in the Senate. And then after EB-5 bill passed into law, he filed one of the very first EB-5 cases in the U.S. in 1991. Since then, we've filed thousands of EB-5 petitions for our clients, and the highest volume of EB-5 that we've handled was probably around 400 to 500 cases per month, because we had multiple rushes, right? So that's the volume that we're talking about. So it's been a privilege and honor for me to be his partner and representing our firm in my capacity as a managing partner. So our firm was named top EB-5 immigration law firm of the year 2012 and has been a longtime member of policy committee of IA USA.
Great. Thank you.
Thank you for the introduction. That's extremely helpful, and it's good to know where you're coming from.
Thank you.
So now we're going to jump a little bit into what is source of funds and how does it actually fit into the EB-5 process. And in the first section, we're going to go relatively quickly about the overall source of funds and the common ways that you would document it, and then we'll really jump into how that applies to South Korean nationals. So when you think about an EB-5 petition, there's two key parts to that petition. The first part is about the project itself. So in EB-5, you're making an investment in an NCE, a new commercial enterprise that's going to deploy the money, and it needs to create 10 jobs through the JCE. So that's step one of the petition. Step two of the petition is all about the individual. And what that really comes down to is about the source of funds, of showing how that $900,000 was legally obtained and having all of the backup related to obtaining those $900,000 and showing that it does make its way into the actual project itself.
Thank you, Mike. So as we dig into the different common sources of funds, in most investors' situations, there's typically 4 different potential sources. First, ordinary income. So that's just working at a job, getting paid a salary. Second, capital gains. You buy a stock, it goes up, you sell it, you have liquidity, you use those funds to invest. Third, you receive a gift from a family member, a friend, or you inherit funds from someone. And fourth, loans from family, friends, or companies, right? So it's pretty much the cardinal 3: marry, earn, inherit in terms of sources, or loans, right? So the key is that you have to document and be able to provide all of the paperwork to be able to illustrate how you obtained at least the 900,000 or 1.8 million, depending on the project. You have to be able to document how you obtained those funds legally. You don't have to document anything above that or anything other than that. You just have to show exactly where that 900,000 or 1.8 million came from. You don't have to prove anything about your total net worth or other questions. It's just, where did that 900 come from? How did you get it? And if there was tax due on it, you have to be able to illustrate that that tax has been paid and the funds were obtained by you legally. So we'll quickly cover this now, and Evelyn will go into more detail later. But ordinary income, what does that usually mean? It's basically just W-2 income if you're in the United States, dividends, business-related sources. If you have documents that are not in English, you're going to have those translated. You have to show that the funds were actually moved, and that the funds that were moved were the ones that taxes were paid on. So it's not enough to just show that you paid tax, but you actually have to show the tracing of the funds, showing how they came from your employer, how you got them, and then how they've moved from the employer to you, and then from you into the EB-5 investment vehicle. So it's two things. It's sourcing and tracing. So where did it come from? And then how did you get it today? And how did it flow from its original source into the EB-5 investment that you're now an investor in? Capital gains, pretty much the same rules apply here. Has to be in English and translated if not already in English. You have to show taxes have been paid, and you have to show the tracing of where the money came from and how it's gone since you originally obtained it into the EB-5 investment. Oops. So gifts or inheritance, same thing here. The main difference here is that you have to show that any applicable inheritance taxes were paid, or if there was a gift tax return that was required to be filed, how that was done, make sure everything was done in compliance. And then in relation to the loan, this one's a little bit more complicated. If you're taking a loan, you have to demonstrate that the loan was against assets that are at least equal market value at the time of the loan for the amount of the loan. So if you have a building worth $200,000, but you're getting a loan that's $500,000, that's not going to work. It has to be a loan that's at least equal or less to the current market value of the asset that's serving as collateral for that loan. And then the same rules apply of being in English, and then showing appropriate taxes have been paid, and the tracing showing the flow of the funds since the sale or since the loan was executed. Okay, so now we're going to dive into those same categories, but with the lens of Korean investors. And obviously, these rules and situations are going to differ substantially country by country, since a lot of investors earned or obtained capital from sources outside of the country. This is going to be important really to work with an immigration attorney who has a lot of experience working with clients from that specific country. USCIS has seen hundreds of investors come in from Korea over the last 20 years from the program. Korea is one of the largest sources of EB-5 investors. So USCIS knows generally what types of documents are available in Korea, and they're going to be on the lookout for that specific set of documents if they see the investor is coming from Korea versus China, right? The types of documents are going to differ substantially between countries. So that's why it's important to really understand what you're going to need and what's going to be required and what may not be required.
All right, thank you, Sam. So this slide lays out all the important pointers, the ordinary common issues that come up for the Korean South Korean investor source of funds, and then we're going to have another slide that talks about the very particular specific issues pertaining to Korean investors. So number 1, ordinary income, and then number 2, capital gains, number 3, gifts or inheritance from family or friends, and number 4, loans from family or friends or companies. So we have each slide for each topic, which I'm going to go over in very great detail. Number 1, ordinary income. So South Korea, fortunately, have a very well organized banking and tax system, unlike other Asian countries, meaning everything is electronically systemized and well organized. So you won't be able to say, oh, because I used to, because my income, I used to work for the company back in 1980s, due to lapse of time, I don't have any tax records. You won't be able to say that because you can retrieve your tax records all the way back to 1980. So let's say you work for the company X, and then you work for the company B after working for the company A for 5 years. Sam, I hear my echo. Okay. And then you work for company C after working for the company B. So you work for company A, B, and C. And now you have to prove that you work for the company A, B, and C for X years of, X number of years, and for the X amount of salary, and you pay X amount of tax. All that information will be memorialized in a document called Certificate of Income for Wage and Salary, or Certificate of Income, Certificate of Global Income. So there are two types of Certificate of Income that memorialize the income earned, tax paid for the years worked, and companies you work for. So Certificate of Income for Wage and Salary is for those who work as a W-2. And it is missing from this slide, but there's another type which is called Certificate of Global Income. That is for those who work for themselves, like self-employed, or have their own business. So you can be both, right? You can work as a W-2 and also be your own boss, have your own business. Then you're going to have global income tax, which shows your wage and salary earned while you work as a W-2, like, employed by another third-party company. And also you'll have, income that you earned as a business owner. So, it'll literally show you all the years you worked, all the incomes earned from which company, and even the amount of tax in a very organized table format. So it is impossible to explain to USCIS saying that, oh, I earned X amount back in 1990 due to lapse of time. I don't have documentation. Literally, you just have to go to the tax office, punch in your number and your data, personal data, and you'll be able to retrieve those documentations. So it is really beneficial for us, especially when our clients want to and need to prove their initial source of funds, which usually tend to be income, ordinary income. Then all we have to do is go to the tax office and retrieve their tax records, either Certificate of Income for Wage and Salary Income or Global Income Tax. Also, South Korea issues employment verification letter. There's a form that each company utilizes, so it is fairly easy to obtain employment verification letter. If not, then we can always use the standard draft template letter, which can be very flexible as long as it contains all the information that we need. Dates, income earned, the amount of income earned, your title, and your wage, the amount of wage that you earned. And also bank statements. So we have to, like Sam mentioned in the previous slide, not only do we have to prove the source of funds, but also we have to prove the path of funds. So after we retrieve all the tax certificates, we also have to show the trail of the money, the path of the funds, by including the bank statement showing the deposit of your income. So bank statement, unlike tax certificates, is hard to retrieve because most of the banks in South Korea do not retain those records for longer period of time. So usually we ask for 5 years, but if 5 years is too much, then whatever the date that you can procure. So bank statement is, especially the recent bank transactions, we tend to always ask our clients to retrieve and procure the documents as much as you can. But as long as they have the income certificate, because it is a government certificate, and we can clearly show their income earned, usually even though they cannot find all the trail, all the passive funds all the way up, usually USCIS has been very lenient on that issue, and I don't think I've ever had any issues proving the income part of source, source pertaining to income. So go ahead.
Excellent. I think one question some people on the listening may have is, so what's the difference between, let's say, South Korea getting this, and how does that compare to other countries like other large countries like Vietnam and China? How much easier is it to prove income in South Korea compared to some others?
Oh, so for example, China and Vietnam, for those who don't really know how other countries work. So their systems, the tax systems and banking systems are not as systematic and organized as South Korea. So oftentimes in China, the investors won't have any old tax certificates to prove that they actually earn money and pay tax. So for those clients, we would have to rely on secondary evidence, meaning we would have to ask our clients to ask their friends and whoever the third-party coworkers that they used to work with, or whoever can, sign the declaration confirming their employment and salaries paid and tax paid. So we would, without any choice, we would have to rely on those secondary evidence. It is not a primary; it is secondary. However, if it's the system and if our clients cannot obtain those documentations because of the system in that country, we would then have to rely on those declarations signed by a third party who can confirm the fact that you actually work for the company, earned this amount of money, and paid this amount of tax. So, and in Vietnam, a lot of people use gold. So, a lot of people purchase gold and they store gold inside their house instead of even depositing cash in their bank. So they don't even have bank accounts. They don't even have anything to prove but gold, that they recently sold gold that they stored in their house for several years. So it's even challenging because they not only are not able to, secure all the documents to prove how they earn money to purchase gold, but also there's no paper transactions to show the purchase of gold, and because they didn't deposit the money in the bank statement, bank account, it's not like they have paper transactions to prove all the source and passive funds. So if that's the case, what we do is we try to find a publication about the culture, the norm, back in the days in Vietnam as to why people had to rely on purchasing gold instead of using the bank to save their assets in their bank account. And then we include the articles, the published articles explaining the culture and their norm and their background as to why they were purchasing gold. That way, USCIS can have a better understanding as to why, and maybe it was a norm in the country without any choice. They had to rely on purchasing gold and storing gold in their house. So if we can find publication to explain about the situation in that particular country, then we always try to include publications and articles. If not, then, in addition to declarations, instead of only relying on declarations.
Excellent. Very helpful.
All right. Do you have any other questions for me? Should I move on to the next?
Yep. Yeah. Let's shift over to capital gains.
Not on income. I think, let's jump into capital gains.
Can you please move back to the income? I'm going to briefly talk about business. Yeah, I just want to make sure that I did not. So for the self-employed business owners, in addition to certificate of income, employment verification letters, you would have to prepare the certificate of business registration and certificate of closure of business. So even for the business owners, the tax documentations would have conveniently reflect the opening of the business and closure of the business. So all you have to do is literally print out those certificates showing that you opened the business and you closed the business. It'll show the dates of, grand opening, dates of closure, so that it is very fairly easy for us to demonstrate that this person had the business, right? And then, like I mentioned, certificate of income for global income shows both business income and salary that they earned as a W-2. And also if they can find invoices and purchase orders issued by the business, always helpful. And business bank statements, I always recommend 5 years. Try to find 5 years. If not, then, whatever that you can find, but more the better, of course, plus personal bank statements if related. Okay, next, move on to the next slide. Okay, capital gain. This is an interesting topic because especially real estate, real property, is something that is, real estate in general is such a sensitive political issue everywhere right now, but especially in Seoul, it's explosive, literally. So South Korea's wealth has flowed into real estate to an unusual degree because there's not that many options available out there for the individual investors. So for example, the country's domestic stock market is good, but not that great. So as of March, just an example, as of March, Samsung Electronics alone represented nearly 34% of the entire Korean composite stock price index market cap, making it so difficult to have stable and diversified investments. And it sort of undermines the confidence of public investors in the system, right? It's called 재벌 conglomerate, like Samsung, LG, Hyundai, all these big companies. So in contrast, real estate is visible. It does not disappear, right? And its value doesn't go to zero as stocks can. So the formula for a winning investment in real estate, seems clear enough, especially in a country where, half of the population lives in one metropolitan area, Seoul. So when the Korean economy began growing explosively back in 1980s, a lot of people suddenly became very rich due to the housing price that skyrocketed in such a short period of time. So in 1977, for example, 1,000 square foot condo in Apgujeong, like in Gangnam, I'm sure everybody heard this song Gangnam Style. Gangnam is sort of like a Beverly Hills in Korea. So, 1,000 square feet condo in Apgujeong city in Gangnam was approximately, let's say, like 10,000 or like 10,000 to 14,000. In 2020, that same condo is worth over 2 million. So that is approximately over 330% in annualized return over like 40 plus years, right? So there are a lot of people who happen to own a real estate and became so rich. Or a lot of younger people, younger generations, who inherited the real estate from their parents that happened to, which value happened to be increased like exponentially and became very rich. So when the EB-5 market was more lively and active, with the rate of with the minimum investment of $500,000, we had a lot of Korean investors, especially younger investors, who inherited the real estate property from their parents, which with the value that literally is way, little tiny condo worth over $2 million, $4 million. For them, EB-5 investment wasn't like too big of a deal. You see what I'm saying? And proving the source of the real estate is relatively easy compared to other Asian countries, like I mentioned, because if, for example, the son or daughter inherits this real estate property from their parents, then we have to prove the source of their parents' money to purchase this real estate property. Even though due to less of time, we cannot go all the way back and always be able to prove their income using the income certificate, at least we can retrieve their records from back in 1980s. And then anything that we need from before back in 1980s, then we can use declarations, third-party declarations to prove the source of their funds that they earned before 1980s, like 1970s or 1960s if necessary. Then after that, it's not an issue because we have tax certificates. And, it is relatively easy to find the banking records, the bank transactions, the bank statements, to show at least the latest transactions, to show the passive funds from their parents' account to their children's account, and also all these inheritance-related documentation. So for those who happen to own this real estate, especially in the city of, Gangnam, or, the area where their housing price literally skyrocketed in such a short period of time, it used to be relatively easy to prove the source of funds. Whereas, like I mentioned, other, and it says the equities on commercial fixed deposits. So it's another interesting concept, only particularly available, not only, but specifically available in South Korea. So in South Korea, most of the banks offer various types of fixed deposit savings. It's called fixed installment time deposit accounts. It's a literal translation. So what it does is that if their customers open up this fixed deposit account and they put in their deposits, they sign a contract for maybe 1 year or 2 years, and within 1 or 2 years, they cannot withdraw any money, but they get the higher interest rate. And this type of, fixed deposit accounts are so popular in South Korea. So a lot of our clients also have this fixed deposit, which also makes our job very easy, because as long as we have income certificate showing that they earn enough income to be able to deposit that fixed amount into their fixed deposit account, then all we need to do is to pull all the income certificates, the latest bank transactional records to show the passive funds, and then which shows consistent amount of withdrawals that transfer to the fixed deposit account. So a lot of our Korean clients also use fixed deposit account as part of their source of funds, in addition to real estate property. And also, as part of the real estate property, we not only have to prove the source, but also the registration. So, so first of all, sales agreement. Oftentimes, people, if it's too while ago, the old transaction, then a lot of people don't keep the sales agreement, or they lost it already. If that's the case, then we try to get the declaration at least by the agent, the realtor who assisted them with the sales, confirming the sales transaction. But always, it is best if they can try to look for it and find it. But if not, then declaration. And then bank statement showing the withdrawals and deposited the amount, the sales amount. And also the certified copy of registry is the title, the deed. So there are two types, building or land. So it can be both. So, and also there's a local tax assessment certificate, which shows the value of the property. So those are the documents that you have to include as part of the source of funds for the real property. All right, I'm ready for the next slide.
So would you say that the real estate is the most common source? Would you say this is the most common source of funds that you use, or about what % of your clients are using real estate as their source of funds from South Korea?
So I will probably more than 60 to 70%, but I wouldn't say real estate is the only most common source of funds, because, or I would say this, real estate is always part of their source of funds. Like more than 70 to 80% of our clients use real estate as part of their source of funds, if not all. But they usually tend to mix with other source of funds, with real estate. Because it's so easy for them to utilize it, you know what I'm saying? If they don't want to sell it, then they usually get the loan based on using the real estate as collateral. But I'm gonna explain about why people are hesitant to use loans nowadays, and when we go over the next the slide about the loan. So now, gifts or inheritance. So
great, and that makes a lot of sense. And for anybody that can invest $500,000 or now $900,000, chances are them or their family does own real estate. And with how clean it is in South Korea to get the records, it makes a lot of sense to use that as a portion of the source of funds.
So for the gift and inheritance, I specifically prepared a separate slide for gift and inheritance when I go over the specific issues pertaining to Korean investors, because Korea, unfortunately, like right now, so far, I've only talked about this positive side of Korean source of funds, right? But there's a negative. So gift. Korea is one of the very few countries that have gift tax, even if the gift is made between family members, meaning parent and children. So their gift tax is not only do they have gift tax that they have to pay, but it's ridiculously high, which I'm going to go over. I prepared a chart to show you how much tax that they have to pay. So gift tax is something that because there's high amount of gift tax, and depending on the amount of gift, the percentage of tax is increased. So when it was $500,000, people try to minimize the amount of gift so that they don't have to pay gift tax. So that's why they tend to mix, different source of funds here and there to make up for $500K. However, with $900,000, I don't think they can do that anymore. And eventually, some investor clients would have to pay the gift. Sam, I think I hear the echo. Okay, now it's better. So I'm gonna go over that chart later, but that's something that I wanted to share with Korean investors, potential Korean investors. But when you think of using gift as part of your source of funds, make sure to always think about proving the source of the donor. Just because you receive gift from a third party like parent or a third party who happens to know you and want to gift it to you, doesn't mean that you don't have to prove the source of that person. You also have to go all the way up and prove the source of that donor's money. And then, for South Korean, they also have to have the proof of the gift tax that is paid. So usually we prepare a gift declaration for the donor, memorializing, the fact that they confirm that, they agreed to give this amount to this investor. There's no obligation paid back. And plus, we always include a statement saying that all the required gift tax has been paid. And then we even include the receipt of the gift tax paid and issued by the tax authority in South Korea. Okay, next slide is loan. Loan is also a very interesting topic, especially because of Zhang versus USCIS. So for those who are not familiar with Zhang versus USCIS, because you don't really have to know if you're not an EB-5 practitioner, then if you're investors, you don't really have to know in great detail, but for those EB-5 practitioners, I'm just going to briefly go over the recent developments pertaining to Zhang versus USCIS. So in this case, so the plaintiff Zhang with one other investor, they file a lawsuit in U.S. District Court for the District of Columbia by arguing that if once the loan proceeds, the loan is lawfully obtained, then it's cash. Cash is cash is cash. It is not indebtedness, because proving the loan lawfully, proving that the loan itself is lawful has already been done, completed, and that's it. Once that cash is in your hand, then that's cash. It is no longer an indebtedness. However, USCIS argued that no, it is indebtedness, and therefore it has to be collateralized and by the asset that is 100% owned by you, the EB-5 investor. So when this issue was very ambiguous and unclear, even recently, we used to always require our investors to make sure to remember to always, get the secure loan that is collateralized on your property asset that is 100% owned by you. So we prepared not only the source of funds documentations to prove that the loan is legitimate loan issued by the institutional lender or the third-party lender. We also have to prove the source of the collateral, the source of the asset that is being used as a collateral. So we have to prepare two set of documentations. Even though the law clearly says, as long as it is loan, then it's cash is cash. So that was the whole issue, and U.S. District Court agreed with plaintiffs. And they confirmed that once the loan is lawfully obtained, then it is cash. And cash is cash, literally. And therefore, USCIS shouldn't require investors to prove the source of the funds to acquire the assets of the collateral. So basically, the court ruled that it doesn't have to be the secured loan. It can be the unsecured loan, as long as that loan itself is lawfully obtained. That case actually was appealed, of course, right? And recently, the U.S. Court of Appeals for the District of Columbia Circuit again affirmed that loan proceeds qualify as cash. So this whole lawsuit was led by attorney Ira Kurzban, the attorney that I highly respect and admire. Literally, a lot of people were so cheerful and so happy to hear this news. But that doesn't mean that just because we just even the appeal, like appellate court affirmed this, affirmed that the loan proceeds qualify as cash. We can't always rely on this because we still have to let the USCIS have some time internally to train their staff and adjudicating officer to make sure that they aware of this change and they don't blindly just adjudicate our cases based on the old adjudication style. So just to err on the side of caution, like just to be conservative and safe, even the appellate court affirmed that loan proceeds qualify as cash, if your investor can, then I think just until USCIS finally digest and register and understand this concept and apply this to in their ordinary, like real, day-to-day practice, not blindly issuing like notice of intent to deny RFE or even denial without knowing about this, because that can happen, obviously. So I think it's better, as a practitioner, I think it's better to still prepare your clients, still recommend your clients to obtain secure loan if possible. However, if it's not absolutely possible, if there's no other way to obtain other source of funds, and if your client absolutely have to rely on this unsecured loan, then you should go for it. You should get a acknowledgement of risk. So you should make sure that you inform the risk so that your client can make an informed decision. However, you should go for it. So for example, in South Korea, what happened was recently, Korean government has tightened mortgage rules. South Korean government tightened the mortgage rules by revising the debt to income to have a more accurate representation of actual income when issuing new loans. I'm going to go over what 전세 means. It's called key money system that is only available in South Korea. But I'm going to go over that in detail later on in the later slide. But because of that 전세 system, it was so easy for the investors to buy the apartments that are under buy the apartment even using the tenant's money instead of their own money, and then make the gap investment, make profits out of it. So when I talk about the 전세 system, you'll get a better idea what it's about if you're not Korean. But because of that issue, South Korean government began to tighten the mortgage rules so that it's becoming more and more difficult to get the mortgage, both residential and commercial. So what happened was, since it's been extremely difficult to get the residential and commercial loans, so first it was the residential loan was hit by this change, and then commercial loan. So people had to rely on unsecured loans, the based on credit. So if you have a great credit, or if you have a lot of properties, then a lot of banks want to issue the unsecured loan because they already know that you have a lot of properties, but it's just that they can't issue the mortgage because of this change in their system. So because of this very unique system and change in South Korea, back in last year, before the law change, back in November 2019, when people were all chasing after, like going crazy, trying to file their case before November 2019, before the amount increase, a lot of people, without any choice, had to rely on unsecured loans. So we actually, even before the appellate ruling came out, it recently came out in 2020, But back in 2019, we had to rely on the first ruling by the district court on Zhang versus USCIS for those South Korean investors who are going through that change in South Korean government, tightening the mortgage rule back in 2019, at the same time dealing with the amount of increase in November. So we had to file the cases based on unsecured loans. I literally include Zhang versus US's argument all over my cover letter, all over, like even intro, body. Like I explained that this is legitimate and cash is cash. It is from the institutional bank, the legitimate bank's money. So there's no question about the legitimacy of the bank's money. And then I even print out the website of the legitimate Korean bank. Like it's a well-known Korean bank. I also printed out the Wikipedia page of the Korean bank to show that it is a lawful money. If this bank issues the loan, then it's a lawful money. Therefore, it should be considered as lawful source of funds because cash is cash. And luckily, we received approval already on some of the cases. Not all, but some of the cases we already have received approvals. It's our case is very unique because we were forced to use unsecured loans. So we had to test the market, test and see whether it works or not. Without any choice, but what I can share with the practitioners is that it has worked. Not sure if it'll work in the future, because if you get unlucky and if you get a very unknowledge officer who's not aware of this change, Zhang versus USCIS, and blindly look at the old template of guidelines, then you can get a nasty RFE or NOI. But what I can tell you is that you can fight the issues. I'm very confident that, with the response, memorializing Zhang versus USCIS, you'll be able to overcome the issue without any problem. So, okay, so now I'm ready to talk about very special source of fund property only for South Korean nationals. So I already briefly mentioned about 전세 system. So this is a rental system. 전세 is rental system that is very unique in South Korea only. So this is how it works. For the duration of the lease, typically for 2 years, or it can be 3 years, the tenant put down a massive deposit with the landlord, usually around 70% of the value of the home. The tenant makes no other payment to the landlord for the duration of the lease, who returns the entire deposit, who then returns the entire deposit, called key money or 전세, at the end of the lease. It's sort of like a lending system. So in essence, the landlord is borrowing money from the tenant at no interest. So the tenant sort of acts like a bank, and there's no interest. So instead of collecting a monthly rent, the landlord then makes money by investing the borrowed deposit for the duration of the lease. So this unusual system is a byproduct of South Korea's period of rapid growth. And even to this day, this is something that the government came up with because, after the Korean War, everybody was poor. Like there was no way that the tenant was able to pay their monthly rent. Like nobody had money. So this is some kind of very creative system, the byproduct that Korean government came up with in order to, while they figure out how to stabilize their economy after the Korean War. So to this day, 전세 is the dominant form of real estate lease. And because of this issue, people sort of began to abuse this system, 전세, to get the benefits, but to make profits. By buying the property using a small portion of their money, and then they get tenants who would pay the 전세, the lump sum amount, then they combine 전세 amount with their little portion of their deposit, and they purchase the property, and then they sell it at a higher price and make that profit. So it is called the gap investment. That's exactly the issue that the South Korean government tried to prevent. And people started doing that by purchasing multiple different properties like that, using the 전세, key money, and then almost like a flipping the house, but using key money. So you're not even using your money, but you're making profits. But if you're literally do that for like, a lot of properties, then it's not really fair for others who are not able to, who don't even have money to get in the system, like 전세 play, right? So that's what happened. So number one, aside from that issue, a lot of South Korean investors use 전세 as part of their EB-5 money. So what they do is the landlord, let's say the landlord is EB-5 investors, and then or it is their parent, and then they give that money that they receive from tenant to their children. So it has worked in the past without any issues for several years. This has been so popular in South Korea, no issues. However, USCIS recently began to raise the issues by carefully reviewing the contract and saying that, oh, so it belongs to the tenant, not you, then it is not your money. It's almost like, I don't see this 전세, I don't think this is any different than the loan issued by the bank. So does that mean that when you borrow money from the bank, then that is not your money? So, once that money that you borrow from the bank, the lawful source of the money, whether institutional bank or third-party lender, once that lawful source of the lending institution, the lender is carefully, proven, then cash is cash, in my opinion. Therefore, you can't make a claim that the key money is not a legitimately sourced money and it is someone else's money. So I'm very confident that this issue will be, we will be able to overcome this issue if this becomes an issue. And I'm sure like soon there will be a litigation on this issue. And if we get an opportunity, and if our client let us handle and litigate this matter by paying for our reasonable legal fees, then we'll be more than happy to. I'll be very interested in litigating this matter in federal court. But in my opinion, cash is cash. And this should just work the same as the loan, as long as the source of the money can be proven and it is legitimate. Number two, unsecured loan by no choice. This is something that I explained. So because of the recent change, Korean government tightening its rule on mortgage loans, people had to rely on unsecured loans, but it has worked. On some of our cases that have already been approved, where other cases are still pending, but I'm very confident that these unsecured loans will be approved, even with this appellate court's decision, I feel even more confident that unsecured loan is not an issue anymore. Number three, a lot of Korean investors, especially professionals like doctors, surgeons, do have many different life insurance products, portfolios as part of their investments, and it becomes a very common source of funds, EB-5 funds, because it's very clean transaction. They show all the premiums paid over the years, so they can get loans against the premium paid to date as collateral. So that life insurance loan is another very popular source of funds for South Koreans. Lastly, there's a mini source of funds requirement only for South Koreans. So for South Koreans, they can transfer the funds out of Korea only up to 100,000 per year. If you want to transfer more than 100,000 per year, then you have to prepare like a mini source of funds report and obtain an overseas migration source of fund confirmation from the local tax office in Korea. So it's not like, it doesn't have to be almost like EB-5 source of fund report, but it's sort of like, it is much simpler, but you still do have to include some important, very important important documentations to prove that all the source of your funds are legitimately obtained and you paid all the required tax. As long as you can prove that, it is fairly easy to obtain the confirmation from local tax office. So once you get that confirmation from local tax office in Korea, then you can transfer out money regardless of, there's no limit. I mean, as long as you can prove all the source of that funds, like $900,000 or 1.8 million, then there shouldn't be an issue. Okay, I'm ready for the next slide.
Okay, great. Great, Evelyn.
Okay, in the interest of time, I'm gonna just quickly go over, I kind of wanna really make sure that they have enough time to go over their slides. So this is the gift tax that I mentioned. This is the chart. So as you can see, the 900K is approximately Korean 1 billion. And as you can see, they have to pay 30% tax. If it's more than 1 billion, depending on the currency, it can be more than 1 billion. To meet 900K, then it can be 40%. So it's somewhat unreasonable amount of gift tax that parents have to pay, even when they want to give money to their own children. So that's why a lot of Korean investors can't just rely on gift as part of, or inheritance as part of source of funds. Appraisal report. So last point is appraisal report required for mortgage loan or sales of property. So in China, for Chinese EB-5 investors, what we do is we include a full booklet, full appraisal report showing the amount of the value, the current fair market valuation of the property, especially when they're using loan or sale of property as part of their source of funds. But unlike China, it is really not common or easy to request for a full copy. Most of the banks would say no. But usually what we do is we include an agreement for loan transactions and an agreement to establish the right to collateral as security and a confirmation of financial transaction. It shows the amount of appraised value that was issued by the bank. And also we include the tax documentations to show, there's like the property tax. Korea also has property tax documentation, which shows the appraised value. So with that document, I've never received on RFE requesting for the full source of funds, the appraisal report booklet like we do in China. So I just wanted to highlight that for those who have never filed EB-5 for Korean. Okay, I'm ready for the next slide.
Great, thank you, Evelyn. So now Mike and I, we're going to quickly talk about a real life example that's a little bit more on the complicated side, just to give people an idea of how this would mechanically work in the case of a loan scenario, which we are seeing a little bit more often in the last year or so. So we're going to take this step by step. So high level, this is a situation where we've got a South Korean national who's going to be the EB-5 investor, and that investor has property, multifamily apartment building in Seoul. And that investor doesn't want to sell that building. And for whatever reason, they've decided not to get a locally sourced loan or a mortgage in Korea for that building. Maybe the interest rates are too high, or whatever the case is. But they do have a friend who's a US citizen in the US national. And that friend has a successful consulting business that's making money and paying tax. And over the last 5 years has generated over $300,000 a year in after-tax income each year over the last 5 years. So in the last 5 years, they've made over $1.5 million after tax. And so that friend has agreed to provide a $900,000 mortgage against the apartment building that this investor owns over in Korea. And so starting with number one here, we're going to kind of talk about some of the documents and things that would be required in this type of a scenario. So first, the investor is going to have to provide all their personal credentials and documents, their passport, birth certificate, driver's license, local ID, all of that information for the investor and his or her immediate family members, husband, wife, and kids under 21. Second, as we mentioned earlier, you're going to have to prove that that investment actually is real, the building itself, and that it's worth at least more than the loan amount, in this case, $900,000. And you do that most commonly with a third-party appraisal done in the last year, probably. And then third, include documents and information on how the investor became the owner of that building. Or it could be a case where they only own a percentage, and then the same types of rules would apply for that percentage of ownership. So did they inherit the building? Did they buy it and a long time ago, and it's since gone up substantially in value? How did they obtain title today? And is there any other debt on it? Then shifting over to number 4, so a loan agreement showing that the money's been loaned, and it's not a gift, and that the collateral or security for that loan is a mortgage, right? Or a lien, whatever the appropriate documents are locally to reflect that if the investor doesn't pay the mortgage payments as described in the loan agreement, then there's some clear path for the lender, in this case, the friend, to foreclose on the collateral. And that's going to vary substantially by jurisdiction and by country, what the rules of law are going to be to really have that security. And so you're typically going to want to have a letter from local counsel explaining how that's possible. And it's going to need to be defined in the loan agreement itself. Then in terms of the capital that's being loaned, the friend who's loaning the money has got to prove that his business is legitimate. It's a US business in this case, so the documents are going to be much clearer. So incorporation documents, FEIN number, operating agreement, where's the business located? Is it registered to do business there? What business is it in? All the tax returns that business has filed. And you're going to need to show that the money that's being loaned was actually income or after-tax income received by that business from various third-party vendors or various third-party clients, right? So you're going to want to show invoices for services performed and compliance with all state and federal tax rules, and the bank statement showing that services were provided at arm's length, what services were provided, what funds were received, so that you can say that that really is earned income for services provided. Then the information, same type of information for that owner of the business, passport, birth certificates, license, all of that. You're also going to need to provide that for the owner of the business as well, to show that that's a legitimate person and who they are, where they are, that's operating that company. So this is a little bit more complicated of a structure, but it does kind of touch on all the different items that we discussed today earlier in the webinar. And again, this is going to vary by local jurisdiction, but in general, if you're getting funds from a loan or a gift, you're going to have to show not only that you got those funds, but where the person who's giving them or loaning them to you got them, particularly if you're getting a loan from a private business. If you were getting a loan from, let's say, Wells Fargo Bank, then you're not going to need to prove that Wells Fargo got that $900,000 and show all the transactions of where Wells Fargo got that money, right? There's going to be a much different standard for a publicly traded multinational bank versus a smaller private operating company. So that's kind of important to note there. Evelyn, do you have any other comments, or Mike?
In every case Yep, I would say that every case is very different, and that's why it's so important to work with a qualified attorney that's worked with people from your situation before, whether it's from your country or from a specific source within the U.S. Working with an experienced attorney always makes this process a lot easier to detangle this complex structure.
Yeah, one thing I want to chime in is, Sam and Mike, is that this chart shows the loan collateral. So it is still my even though I went over Zhang versus USCIS and even unsecured loan works, even though I said that, and Zhang versus US, with the appellate court's ruling, I feel more confident, but I am more of a conservative side, and I also don't think USCIS officers would right away apply that and agree or be able to digest it and train all of their adjudicating officers, especially for the new one. So while they figure that out, and might take time, I would err on the side of caution and still use the secured loan if possible. And I would only recommend to use unsecured loan if it's absolutely, necessary. So that's one point I wanted to make. So that's why it shows loan collateral. So before, it was a standard practice to always require collateral, and make sure that the asset is 100% owned by the investor.
Yep, that makes sense, and we definitely agree with that as well. So now to help people kind of illustrate exactly how the source of funds comes together, as Mike mentioned earlier, when investors file their I-526 petitions, they're submitting a package that includes a lot of documents explaining the project and how the EB-5 investment itself meets EB-5 program rules and regulations under USCIS. And so usually there's a cover letter which explains all of the project details and also explains the source of funds information as well. And so to help kind of illustrate how those that cover letter document typically comes together, we've included this free template which kind of explains a fictional scenario to give people an idea of what types of documents and how many exhibits and what things are going to be required potentially to be included. And again, this is going to vary substantially by investor and their financial personal situation. If they own real estate, if they're employed, if they're self-employed, if they're employed by a large company, this is going to vary dramatically. But to give you an idea, we've put together this outline, and it's available on our website. The link is there, and here's a more detailed explanation about just some of the types of exhibits that you would tend to find for a filing. And basically, the most important thing to realize is there's going to be a lot of exhibits, and a lot of them are going to be bank statements and records and official documents, tax records. And so it's not going to be something you can just pull together in a few days. You're going to need to meet with immigration counsel and determine, exactly what documents are going to be recommended, which ones of those recommended documents you'll actually be able to get, and then, start the process for obtaining them, organizing them, getting them translated if necessary, and then working with immigration counsel to make sure that you're telling a compelling, logical, and very easy to understand and follow story to the USCIS adjudicator who's going to review your file and ideally quickly grant approval, because there's nothing that's incomplete, or any potential questions that could have come up have been addressed within the documents and letter that were provided. Evelyn, Mike, do you guys have anything else to add on that?
Perfect. Now we're just very not on this one.
No further comments.
Okay. So we'll now shift gears and talk a little bit about two current EB-5 projects that we have that are open to investors around the world, including Korea, and then we'll shift over and answer the questions that have come in.
So yeah, the first project that we want to discuss, and as a disclaimer, this is not a solicitation of securities. We're giving some preliminary info here, and if you're interested, please reach out to us, and we'll make sure you are an accredited investor and provide all of the details. But the first offering that we have here is the Hyatt Fort Lauderdale project in Fort Lauderdale, Florida. This is a Hyatt-centric hotel on the bottom, luxury condominium project at the top. And this project is actually nearly done with construction already. The hotel recently opened, and the developer is finishing the final punch-out items on all of the condominiums project. It's located central on Las Olas Boulevard in downtown Fort Lauderdale. There's a senior bank loan in place from CIBC. And one of the more unique things about this deal is that it is an EB-5 loan structured with a 2% preferred return to investors. We have a little under 10 slots left in this deal. and there's a lot of interest in this, and investors are welcome to visit the project and go and check it out.
Thank you, Mike. One other point to mention about this project is most EB-5 projects that are structured as loans are typically done with the collateral of the loan being the individual project. This project is a little bit different in that the loan itself is secured by a parent guarantee, an EB-5 loan repayment guarantee from the developer's parent holding company. The developer of the project is the Coulter Group. They're one of the largest real estate development companies in the Southeast United States, and they've been in business for over 25 years and have a substantial track record of building thousands of condominiums, hotel rooms, all throughout the Southeast with a focus on South Florida.
And our second project is a little different in that it's an equity investment instead of a debt investment. And because of that, there is a higher return associated with that. It's 6%. Now, this is a luxury condominium project in downtown St. Petersburg, also being developed by the Coulter Group. And it's actually a follow-on deal to a prior EB-5 deal that was funded, One St. Petersburg, which was right down the street, about 3 blocks away. And this project is coming along well. There's a senior bank loan in place from Wells Fargo. The developer broke ground several months ago, is working on all of the groundwork at this point, and is very close to being able to pour the foundation and start going vertical. It's also has the exemplar approved at the $500,000 level. Of course, now the investment amount has increased to $900,000, but that's the only thing that's changed. So both of these projects are great options. They're being built by a very respected developer in Florida. They've both had exemplars approved on the project. They're both located in targeted employment areas and are at the $900,000 investment level. And we're happy to discuss either of these projects in more detail. If you reach out to us directly, we can take it offline and talk through them.
Great, thanks, Mike. So we're now going to shift over and address some of the questions that have been asked during the webinar. And so the first question that we got was about the mini source of funds that Evelyn described earlier. So the question was, who works to prepare that mini source of funds? Is that done by the client or the immigration attorney? How does that work?
Usually it is done by the migration agent, and usually most of the experienced EB-5 migration agents in Korea who are experienced in EB-5 are able to handle the entire process. So they, like, literally, I don't even have to worry about getting the mini source of funds, but that also helps us because, you know, that is part of the process for my work too. So the more experienced the migration agents are, the better. However, when we deal with the individual one-off investors, like my friends or family client, refer clients, or somebody who don't have migration agents and directly come to me through a referral or introduction, then I would have to work on that with those individual investors. And the client actually has to either designate somebody in case he or she is like a busy person, like executive of the company, who happens to have the assistant. Then we usually tend to work with those assistants. If not, then the clients will have to prepare those documents under our guidance and supervision. So we tell them where to go, and what kind of documents to obtain. Because we do this so many times, we do already have a guidance and template, so sort of like information package as to what they have to prepare. So unfortunately, if it's one of client, then client has to, go through the process and prepare the documents. But it's not that too difficult. Like it's fairly easy because it is mini source of funds, not a regular like EB-5 source of funds.
Great, thank you. Next question we got was, what is the current estimated processing time for an investor filing their I-526 from Korea to get approved?
So with the expedited approved project, we tend to get an approval faster than others. The fastest approval that we received was less than 3 months. However, for the regular projects, it's a typical 2.5, 3 years. And if it's more than 3 years, then people consider filing a writ of mandamus. So it's same as other, we don't have unusual delay processing for Korean investors. And it also depends on the projects too. Some projects, their processing time is a little bit faster than others. But
got it. Another question that we got kind of related to that is, how does the mandamus filing work? What is that, and when is that appropriate for an investor to pursue?
Okay, so writ of mandamus is something that investor can consider filing in case the I-526, their initial stage is being delayed. And even though, so for example, if you go to USCI's website, there is a processing time that they put on their website. And their processing time is just ridiculous. And it'll show up to 6 years. Like I think it recently, right now, it's currently showing like up to 3 years, up to 6 years or something like that, which is ridiculous. And there's no way you can wait until 6 years until your initial 526 is approved, right? So usually we recommend them to file, consider if they really, so before we even consider filing writ of mandamus, we start submitting an inquiry as to what's happening and ask for the update as to what's happening to their I-526. We usually give about 3 to 4 chances, and then after about 3 years, some people want to file an action in court after 2.5 years, but we usually want to wait at least for 3 years. So writ of mandamus is like a solution for pending EB-5, the 526. So federal district court can provide somewhat effective option to solve the issue of long pending applications. So this petition is brought under the Administrative Procedure Act, or APA, or the Mandamus Act, to compel an agency like U.S. government agency like USCIS to perform its duty to act when some kind of adjudication is unreasonably delayed or impermissibly withheld. So, under APA, courts can generally determine whether they will compel agency action or not. So, when, filing for writ of mandamus, courts look to whether there's a statute or regulation that mandates a specific time frame for adjudication, whether the plaintiff has a right to the requested relief, and if the plaintiff has any other adequate remedy. So we draft complaint and asking for the government, the USCIS, to look at this statute, the processing time, and also we explain, why this unreasonable delay negatively impact our investor, and we filed literally a complaint in federal court to prompt the government agency to act, because they're obligated to perform its duty to act. So usually, when we file this case in federal court, government has 60 days to respond. And in many cases, we get the movement within those 60 days by working with the assistant U.S. attorney, or AUSA. So they usually represent, so AUSA is the attorney who represents the government, USCIS, and we have back and forth communications and correspondence with AUSA, and AUSA relay the message to USCIS, and usually USCIS issues another request for evidence, or sometimes they issue notice of intent to deny if there's any issues that are sort of deniable, but usually they either issue the RFE or approve the case. If the case is clean and there's no issue to be raised. So what I always recommend is, finding it early and knowing knowing what's going to happen, it's not going to change the outcome. Just because you filed a writ of mandamus filing doesn't mean that you're going to get the nasty RFE or NOID, or your case can potentially be denied, because at the end of the day, you're going to get the same issue anyways, right? Even if you don't file the writ of mandamus. But in case your client needs some time to prepare, the additional documentation in the potential issues that they think and they can anticipate early on, then I highly recommend to carefully review the source of funds with the client and see when would be the right time to file writ of mandamus. Just because it has been pending and delayed doesn't mean that you want to blindly file writ of mandamus without analyzing the source of funds and see whether there's any issues that can be raised in RFE. You definitely want to be ready for it before you file the action in federal court.
Great. Thank you, Evelyn. So that will be the last question that we'll be able to cover. So any other questions that come up related to this material, please reach out to us. The contact information, email, phone number details are on the slide. And again, if you want to review a recording of the webinar, it's going to be on our YouTube channel. Just Google EB-5A on YouTube. And if you'd like a copy of the slides that were presented today, just email us, info@eb5an.com, and we're happy to provide those. And any questions related to the projects that we discussed, the Hyatt Fort Lauderdale project or the Saltaire project, please reach out to us. And any immigration related questions, please reach out to Evelyn. And thank you again for taking time to join us today. And thank you, Evelyn, for helping us and sharing your insight into the Korean market.
Thank you for inviting me. It's my pleasure. Bye, everyone.
Thank you, everyone. Bye.